The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the City's Unified Development Ordinance, also referred to as the UDO. We are authorized to hear requests for variances from the UDO, appeal from final determinations made by city officials charged with enforcement of the UDO, requests for reasonable accommodations, and other requests as may be provided in city ordinances. Our first agenda item is a review and adoption of the minutes of the July 22nd, 2024 regular meeting. Is there a motion?
Motion to accept.
Second.
Second.
All in favor say aye. Aye. We now begin the evidentiary hearings for the cases listed on the agenda. The board conducts quasi-judicial evidentiary hearings. This is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other types of land use decisions, such as rezoning cases, which are legislative in nature. The Board of Adjustment's decisions are constrained by the standards in the city's ordinance and the facts presented. The board hears and considers evidence presented at the hearing and applies the standards set forth in the UDO and state law. The board must base its decisions upon competent material and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. This meeting is open to the public, however, participation is limited. Parties have the rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Witnesses may testify to facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, layperson or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. For variance requests, a 4/5 vote of the board is required to grant the variance. For all other hearings and matters, including the adoption of the minutes, the decision will be made by a simple majority vote of the board. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide testimony. Please stand and raise your right hand if you plan to provide testimony. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I believe we may be adjusting the agenda a little bit.
Yes, Madam Chair, if I could address the two appeals first. You'll see listed there that the appellants are represented by Brandon Freeman. Mr. Freeman's not available, but I believe a representative from his office is and can speak to the reason why I believe they're requesting that these matters be continued, and I can affirm that the city's not going to oppose that motion once he has a chance to speak.
Okay, would you like to come forward?
Good afternoon. My name is Jesse Swords. I'm an attorney with Allen, Stall & Kilbourne. And like Mr. Edgerton said, I think both of the appeal matters, we're requesting continuances. For the notice of violation appeals, Brandon Freeman is taking care of a close family member that went into surgery on Friday. And then I think the city was going to either join or suggest that we continue the second one. Do you want to confirm?
I think we're gonna modify the entry on the agenda based on some concerns that we've heard and have that entered slightly differently on your October agenda. But in either event, given the medical emergency that's come up, we obviously are not going to oppose the continuance of both matters to October and would request that it be granted.
Okay, so we'll be looking for a motion to continue the items until next month's meeting?
Yes.
That's correct, and that is October 28th.
October 28th. Can I get a motion?
A motion to move it to next month.
Can I get a second?
Second.
All in favor say aye.
Aye.
Okay, we'll see you next month.
Thank you very much.
Thank you.
Sorry.
Goodbye, Paul. See you next month.
Good seeing you again.
Goodbye, Mr. Sneed. Okay, so we will now head to our only other application, which is a variance. The petitioner, Andrew Weaver, is requesting variances to the setback standards in Section 786F5, RM8 Residential Multifamily Medium Density District setbacks, as well as aquatic buffer standards, 712-2E2A1 and 712-2F3A. The applicant is seeking relief from the required front setback from 15 feet to 10 feet, and relief from the 30-foot aquatic buffer standards for both temporary and permanent impacts to the aquatic buffer to construct a single-family home and required site improvements. The properties are known as 30 and 32 Waynesville Avenue with respective pins of 9638, 77, 8224, and 9638, 77, 8212. And Tyler Kelly, our residential review specialist, will be presenting the case this afternoon.
Okay, Tyler Kelly, residential review specialist with the Planning Urban Design Department. Here presenting for 30 and 32 Waynesville Avenue, the identified pins below. Here is the location of the two subject parcels. You can see it's in a sea of residentially zoned properties with RAD NT to the northeast. And if you're familiar with the area, this is Waynesville Avenue connects right where the New Belgium site is. So it's just north of this screenshot. Here is an aerial view of the property. You can see Waynesville Avenue identified by the blue line and the stream, Penland Creek identified by the green line. So the first setback, or the first variance in this collection of variances would be a variance for RM8 district for the front setback reduced from 15 to 10. And then here are the, here's the text from 712-2E1A1 and 712-2F3A. It's a long way of saying impacts to the aquatic buffer for permanent as well as temporary impact due to construction. So the RM8 setback, oh, I messed this table up. No, there we go. Okay, so the front setback is at the bottom. So that's a 33% reduction. For the first variance related to the aquatic buffer, it's no land disturbing activity shall occur within a 30-foot undisturbed buffer around all perennial and intermittent surface waters, and that's measured from the top of bank. The applicant has supplied a couple site plans, and based on my analysis and what they've submitted, it'll be an encroachment of approximately 4,511 square feet to the 30-foot aquatic buffer, a near 51% reduction in the total aquatic buffer area of the subject parcel. We'll look at a couple of site plans that will give you some better visuals to that. And then again, a reduction of the 30-foot aquatic buffer to near zero. If you remember the case a few months back, you know, the aquatic buffer kind of started towards the middle section of the subject parcel, and these two parcels, the aquatic buffer actually reaches rather close to the property line facing Waynesville Avenue. So it's a near 100% reduction of the aquatic buffer boundary on the west side of that aquatic buffer area.
Is that due to the top of bank just being further closer to Waynesville Road?
Yeah, it kind of, you can see here, it just snakes a little bit farther west.
Okay.
Yeah. So again, subject parcel areas are located in West Asheville along Waynesville Avenue near the River Arts District, south of New Belgium Brewery. The board has heard and approved numerous variances for single-family dwellings along Waynesville Avenue and neighboring streets, including similar cases on these subject parcels a few years ago. The existing site conditions shown via the applicant's site plan show two roughly 0.06 acre properties. Both parcels are considered substandard as they do not meet the minimum square footage required for new lots within the underlying zoning district RM8. Parcels have the first parcel has a 79.24 foot frontage along Waynesville, and the second one 71.25 along the northern boundary, and then a 77.07 along the southern property boundary. The property slopes downwards from Waynesville Avenue, so to the east, to the stream towards the east of the property. After the stream, the property slopes upwards further to the east towards the neighboring property. Parcel known as 32 Waynesville Avenue has an average percent slope of 33.35, and the parcel known as 30 Waynesville Avenue has an average percent slope of 25.6. The applicant is proposing two 576 square foot footprint single-family dwellings constructed on standard block foundation along the frontage of Waynesville Avenue with a cantilever piered foundation stretching towards the stream, and they can give a little bit better explanation of that design than I can, but there's a couple documents that illustrate that as well. The single-family dwellings are proposed as 3 stories, 28.7 feet tall as measured from the street side, with a ground floor garage, a living room, kitchen on the 2nd floor, 3 bedrooms on the 3rd floor. Unlike the previous case, the parking will occur within a garage. So here's just a breakdown of the permanent disturbance and temporary disturbance within that 4,511 square feet. And then we'll get into some of the visuals here. So here you can see the 2 subject parcels along Waynesville Avenue, 30 and 32. I think I did a closer shot of that. But you can see the Penland Creek as delineated by the green lines. That's the top of bank with the aquatic buffer on the western portion that's being affected. The line is shown in blue. And then those are the approximate footprints of the home within that dashed line, as well as the original setback with a 10-foot reduction shown. So I just wanted to illustrate that this whole portion of the aquatic buffer will not be impacted at all by the construction of this home, or these 2 homes.
Permanent and temporary?
Yes, no impact at all on the eastern portion of the creek.
Oh, I got you.
Yeah. This is applicant's site plan for grading and erosion control. They're showing straw matting as well as straw wattles, and then a silt fence basically right on the border of the creek. So any area to the plan left shown here will be the area impacted. Anything right of the silt fence won't have any impact, just to reiterate that again. This is a site plan also provided by the applicant showing intentions to design a rain garden around the homes. They've just shown an example for one of them. Similar to the previous case, any aquatic buffer variance once granted, there is a document attached to the folder, shows the city ordinance for the requirements for any permanent aquatic buffer impact, requires a remediation plan, replanting plan. So upon granting of the variance, if so granted, then in the normal application process, city staff will review a formal remediation plan as a part of that permitting process. Here's just a closer shot of that.
So this plan has not been reviewed or approved in terms of the landscaping for the remediation?
No.
So I get confused with, between the temporary and permanent, what's temporary?
So the temporary disturbance will be all the disturbance related to the construction of the home, which is a nearly 100% impact to the western portion of the aquatic buffer, with the permanent impact being the footprint of the home.
So like the built infrastructure, the driveway, sidewalks, and all that?
And that breakdown is here in this table. That concludes my presentation. Any questions from the board? Other questions?
I feel like in our packet of information, we did get another site plan that showed the drive aprons. Do you have
There's a
that?
couple of additional documents there. Topo, the Buncombe GIS imagery, which is actually a little bit better. This was the original site plan that was sent in upon application. City staff determined that this wasn't quite enough, so that's why we have the survey and some further detailed site plans. Maybe that's the one you're speaking of, but it'll be a standard driveway apron entering into a one-car garage.
And it doesn't appear that that drawing or that sketch, which I see what you're referring to, it has dimensions on it, but it's not to a scale. Do we know whether or not that driveway apron location would be approved for a driveway permit? Or are they gonna have to go through a modification process with that?
I'll let the applicant speak to that. I don't think that they'll need a modification for just a standard driveway apron. They have some decent frontage for both homes. If anything, the modification would be for distance to the property line.
That's what I was thinking, but
Yeah.
without having the virtue of setbacks or scale. And is there any concern from the planning department, zoning, or transportation on how close the house is to the edge of pavement in order for a car to back out? The question I had is, would they be backing all the way out into the road before they can actually see whether or not there's traffic going up and down Waynesville Road? Or Avenue,
Does-
sorry.
The UDO is not great at describing that requirement. It will operate functionally like any other reviewed driveway in the city of Asheville. There will be, at least 10 feet from, the facade of the home, and then the edge of the right-of-way, and then an additional 2 or 3 feet. We did get a measurement from the applicant. Waynesville Avenue is 18 feet wide, and that's just the pavement. So there's an additional 2 to 3 feet, depending on, the angle of the property line compared with the right-of-way. So my opinion is that there's enough room to be able to maneuver in and out of the driveway safely.
We seem to see this a lot in West Asheville. Is there any way they could build a house and not ask for variances on this lot, or is it just the lot's just too small?
The only way to do that on these subject parcels would be to have the stream piped. So these are functionally undevelopable otherwise.
If the lots were combined, would it meet standards?
No. So the aquatic buffer you can see here runs all the way to the property line, and I believe that's somewhere around 550 square feet shared between the two subject parcels. So, yeah.
Does anyone have any more questions? Oh, go ahead. All right.
So your only concern here is the affected area, which is the blue line, am I correct?
Correct.
If you, I'm sorry.
No,
No?
go ahead.
No.
I'm still thinking.
Okay. We can be Chip and Dale later. The parcel that looks like it's listed as number 1, or the one further south, it looks like the proposed building footprint is also encroaching on the side setback. Is not included in the application.
I'll let the applicant speak to that. I missed that on the review. We could potentially include that in the first variance, a reduction of 6 to 4.8. That's my mistake.
I would also like to point out for the board that this is only for conceptual review of the variances. This has not been submitted for the required building and zoning permits. That is something where if you do not grant the variance, that they would then have to adhere to the setback. Looking at this now, this happens often, especially with many of the surveyors in town and out of town, is they'll just match or sort of point the lines. So there are any number of comments and conditions we provide as residential review specialists back 100 years ago when I had Tyler's job, that guarantee that stays in. So if you do not feel comfortable with that encroachment, I think what's happening is this is probably more likely than anything a drawing error, but we can also let the applicant speak to that. And that's it. If that's something that is not addressed here, I think the ultimate point that I'm trying to make is that it will be caught when it is officially submitted for zoning review.
I didn't want them to have to return for another variance, if at all possible, if that's something that they feel like they need as we go through the application. Does anyone else have any other questions for Tyler? Okay. Thank you, Tyler.
Thank you.
We'll probably call you back up here. Do the applicants have a presentation or additional testimony for the board to consider if you would like to come forward? Thanks.
Good afternoon. My name is Andrew Weaver. This is my wife, Heather. I'd like to thank y'all for your time today, and I'd like to thank Tyler and Daniel and Sam for their efforts in helping us get all this together. I'm a semi-retired builder. I originally started building in Buncombe County in 2003. Got a little stressed out around 2012 and kind of got away from it. It's the first time I've ever had to do any of this stuff. I am a certified green builder, and these two homes here would be green built, energy efficiency being a key there. And my wife is a semi-retired realtor.
30 plus years in Asheville.
Yeah, in Asheville. We're both native to Asheville. We've lived here our entire lives. The aquatic buffer is important to me. I'm an outdoorsman. Water quality is an issue that I see. I have seen my entire life living here, fishing here, being around. I would like to just make it clear that I'm going to make every effort I can to protect that creek. I get it's very important to the community as well as myself.
I'd like to speak up because the outside area, he does the building stuff, but I'm the nature person, and I'm the one that likes to do, and I did the pretty drawing. So do not make fun of my drawing. I'm not an artist. But, so he's pulling that up. So as far as the outside goes, we did one house that we actually made it a certified wildlife habitat, and that was when we had a little house over at 7 Acre Crescent. And I just loved it. I absolutely loved doing that. And so my biggest thing is I live to do landscaping and planting and that kind of thing. My family is a first Buncombe family. We've been here before everybody else was. And so my father, he worked for the city of Asheville and died for the city of Asheville. And he made it a huge deal that it doesn't matter if you're the county or if you're in the city. All of us, we're all together. We're all one. And it's just super important to me that I replace what we used to be. Because what I see now is not what we used to be. I did not grow up with the city being this packed and this many people. So as much as I can put back into the city, because this city has been my livelihood growing up and everything else. So I want to put back into this law and into this area. I don't know if my drawing can we find my drawing in there? So it's important to me in making sure that we put the land back to better than originally planned. So the house itself on the roadside is just a wall. We specifically chose a house that could be built on this property so that the land has so little disturbance that it's not an issue or a non-issue as much as possible. But we do need housing. It's been a huge issue. There's just not enough housing. So the front wall that runs along the road, and then there's 2 piers in the back, those will keep the house up off of the land. You can see in the upper corner there, it shows. So all of that area that's underneath that, you have a front wall that's just basically right there at the road, and then you have your 2 piers. Every bit of that is going to be land that's going to be rededicated back to the wildlife and back to the reptiles and the plants and the animals. So I plan to go, and we're on family land, and we're on a farm. I want to transplant our moss, our rocks, collect it all together and share that with the city, share that with the owners of whoever would be on this lot, or these lots. And moss itself will take back over, and the rocks will come from our farm and all of that. So it's giving back is the way I see it. But everything will be done. We've put in some phone calls to Riverlink. We haven't gotten called back yet. But we want to do everything in conjunction with them because we want the streams and the waters to be pure. They've got to be pure as they can be. And all of the plants that are going to be planted are going to be native. And we have the stormwater runoff. And we want to put into place the rocks and the native plants that will filter any stormwater runoff that comes from the road into down towards the stream. But we want to make sure that there's this will probably have more foliage at the end than it does now. That will be conducive to the environment. And we also will put in a house for birds and that kind of thing. But we want to help the migrating butterflies. We want to help the reptiles that are currently there. But we want the natural landscaping that we'll put in to take care of the water that runs off, because the water that's running off of the roads is just not as clean as what's already there. So we'll also have 2 rain gardens. And the thought process is Waynesville Avenue has a slope that comes down. So the water that's going to reach the upper corner of that property first is going to filter through down beside the house, and there's going to be the rocks and the plants that will filter that through. And it will come down to the first rain garden on the upper part of it. But on that side, to keep it from being overwhelmed, we're going to put a rain barrel on that side, so everything kind of comes to a rain barrel, and then it has to filter through from that to the first rain garden. The lower corner of the house will not have to have a rain barrel because it will have less load of water. And so that can run into the lower rain garden. So there's 2 actual rain gardens. One will be larger, which is the upper side, which is where your water's going to be flowing from Waynesville Avenue. And then the lower one will catch any overflow from this rain garden. And this lower rain garden will be catching the lower end of the house from the gutters. So that will help to mitigate anything, because whatever comes down, it's gonna have to go through what we're putting down the side of the house and through both rain gardens before it ever even comes close to reaching the stream. So by the time that water gets down, it'll be completely filtered and just as clean as it can be. But we want to be able to put parts of our family land into this, and that way it's almost like giving back to the city and giving back to the land. And so whoever lives in these houses, they really will not have to do anything to this. The least amount that anybody has to touch it, they can just be part of nature and still be part of the city and help to take care of the housing crunch that we're in. So that's my excitement. I'm super excited about that stuff. So I'll let him talk to the building part of it, but that's my passion. So.
Mrs. Weaver, have you discussed with the stormwater or erosion control your plans to do the rain garden? Has this been reviewed by or discussed with anybody over there?
No, it is not. This is procedurally awkward because this was previously reviewed. It was denied. It went to district court. It was required to go back to the Board of Adjustment in 2018. It then lapsed. So there is still some private negotiations between the seller and the purchasers that the city is not party to. They're working that out. Ultimately, they decided because the variance had expired that they would make this their first stop. That is actually the cleanest way forward for this. So she has not been in contact with either Rick or Laurel about any remediation that will be happening. But that is certainly relevant to their ability to build and remediate the aquatic buffer. So that will be required as part of that process, but it is also within your purview to consider for their variance request.
So as a word of caution,
Yes, ma'am.
if you put rain garden on a drawing, they're gonna want to see stormwater calculations for that. And I think that's above and beyond what you're probably really wanting to do for single-family residents. I applaud your efforts. I would encourage you, if you haven't already, to read the resolution as at 10-141, because your plan is very well thought out. Remediation is a lot simpler than what you're proposing to do, and you're opening up yourself to a large can of worms in terms of trying to have it over-engineered, potentially doing an operations maintenance manual, all of these things that you don't want to do as, if you're going to hold on to these as rentals, it's fine, it's your responsibility. But if you're going to turn around and sell them, you're going to be selling them to somebody that would have to maintain those and report on them yearly.
Okay.
So I just wanted to, also just for the board, fantastic concepts. It does open you up to a whole lot of issues that you may not be quite aware of. You can simply remediate with riparian seed mix or live stakes or things of that nature. You might want to coordinate with a landscape contractor that does stream bank restoration. That would be my, just didn't have anything to do with the variance. It's just me giving you a little bit of advice.
Yeah.
So not in
Like
for any
she's-
root surprises.
Like she said, we reached out to Riverlink, and the drawing and everything on there was based off of recommendations on their website.
Yeah, we used all of their recommendations.
And those recommendations are fantastic for just a homeowner that's not working inside of an aquatic buffer.
Gotcha.
Okay.
So you may want to just take that into consideration.
No
So
problem.
I would just read that and just know that.
Keep it
that may-
simple instead of being so passionate about it.
You can still be passionate about it.
I can do both.
Yeah.
I just love it. I really enjoy plants and just making things be better for everything, so.
So we don't need to be necessarily concerned or have issue with the background information that's going on between
Correct.
buyers and sellers and all of that. We're just looking at the straight applications and what they're
We are not party to that.
So I'm sorry that is where you find yourself in that regard.
No problem. So to address a couple of things on Tyler's, one of the things Tyler pulled up there said the house was going to be on a regular block foundation. This is a drawing from Medlock and Associates here in town. This is our actual foundation. It won't be a full block foundation. It will just be that one U-shaped wall will be up on the Waynesville Avenue side with the two piers in the back at the creek, and that shows the cantilever there. You had asked about dimensions on one of the site plans. Those were scaled off of the survey. And visibility backing out, there was a picture, sorry, I'll have to get him to pull the picture back up. There's a picture I took from Waynesville Avenue that kind of shows where they would be backing out. And the best answer I can give you to that question is it's kind of gonna vary by vehicle. I think a standard vehicle is not, you would not be in the street when you could see both directions out of the garage. You can kind of tell looking there that the road is straight through that area. There's no surprise curves or nothing. But you would have that 10-foot area between the garage and the road before you were actually in the road.
Does anyone have any questions for the applicants?
Just one point of clarification. On reviewing when the formal plans come through, I will, or whoever reviews the plans, will be required to put a condition that there's no parking within that front section of the driveway. The only parking legally that can occur is within the garage.
I have a question.
Yes,
So did you, I saw this was purchased in end of July, is that right?
correct, yes, sir.
Did you buy it with these, with the understanding that these are in place?
So this is a little tricky. Through where I work now, we have a customer who's a builder who has built several houses on Waynesville Avenue. He approached the owner of the company, stated that he was in some financial difficulty and wanted to sell these lots. He was very enthusiastic and obviously very convincing in that these lots were completely buildable and everything was ready to go. He provided some documentation, which is not really worth the paper it's on. I did my best to do due diligence to verify this, and spoke with someone at the building department who told me that the lots were buildable. Obviously, there's some interpretation to the word what is buildable, but we took that as there's no problem here. We can purchase this property, we can get building permits, and we can construct a house on it. Again, I built in Buncombe County for many, many years. I built 2 houses in the city. I'd never had to deal with this. So this, there was no, the surveys I was given, the documentation I was given is all legitimate, but at this point in time is worthless. And I don't know if the person who sold us the property knew that and deceived us, or if they too were deceived by the previous, or I guess the person who originally applied and had variances for this property in the late teens, and then they subsequently sold it to the person that we bought it from. And we're just trying to,
muddle through this.
yeah,
so.
just trying to get
And you
through.
would think real estate agent, builder, but we did our due diligence.
Yeah,
so.
we felt like we had done our due diligence and that we were buying property that would not require us to be here for meetings like this and have to go through all this kind of stuff that we could have already broke ground, for that matter.
And we do understand that we can go back to the Army Corps of Engineers. We can get another, we can get it piped, the stream disappears. I don't like it.
I don't either.
It's not who I am, and I'm dead set against it, but this is also an investment, so.
Yeah.
So which are the hardships of this placed upon you, if you can?
I've got 200,000 rings in, sir.
What you mean?
That's what I paid for these 4 lots, and I'm on the hook for it. So
We're-
without this variance, I'm out 200 grand.
It's our savings.
Yeah.
my understanding, I guess a question for the city, prior knowledge doesn't affect the, correct? Because this has
Yep.
come up before.
Mm-hmm,
And
correct.
that's the catch-22 we're in, is that they're unbuildable lots, people buy it, and then the hardship is the fact that it's unbuildable, so then they ask us for a variance because they have a legitimate hardship.
Our ordinance expressly says that knowledge of a condition that would warrant a variance is not creating the hardship yourself. So knowing that a lot has problems is not a basis to deny a variance.
So it's a catch-22, that the hardship obviously exists in this case, but it's also prior knowledge of the hardship that we can't consider.
When I look at hardships, and financial hardships are not really what we base our variances on. These properties all along Waynesville, we've seen several of them. They're steep, they have aquatic buffer, they're very, very small, lots are very tight. I feel like you have a very compressed and condensed building footprint, so you're trying to work with the land, you're doing the more, in my personal opinion, really, the cantilevering is a fantastic idea, and so, and it's more expensive, but it is definitely taken into consideration trying to compact that footprint as much as you can and not impact the buffer any further.
Yes.
If the lots are deemed existing non-conforming lots, then as long as you can get the variances that you need, they are buildable lots.
Right.
So from that perspective, I think the topography of the land and the existing streams and the fact that they are pre-existing lots that have the opportunity to be built on works in your favor for me for granting a variance. I'll just put it that way.
Yeah.
Because those are hardships that run with the land. Does anyone else have any other questions for the applicant? Okay. You guys can sit down, we may call you back up. Thank you. Is anyone from the public here that would like to give expert testimony, or any residents with standing that would like to provide testimony? Come forward. Were you sworn in, sir?
No, I walked in right at 2 when you guys started, so I didn't know if I could.
Okay, we can swear you in real quick. Let me go back. Do you solemnly swear or affirm that the evidence you shall give to the board and this action shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name.
Micah Rogers.
Hi.
Hi.
And,
I would ask for standing.
yes.
Yeah, sounds good.
Tell us a little about yourself.
Sure thing. I'm a registered landscape architect and a general contractor, so I think I have expert standing from that stance. And I live just up the street, so I'm a neighborhood resident that walks and bikes and drives the street daily.
What is your address?
53 Tremont Street.
So the question of special damages and whether he has standing is only applicable if you're asking to participate as a party. And so we need to know whether you're asking to participate as a party first.
I'd like some clarification on that. I'm not sure
So
what that
that
means.
would mean that you would be able to ask questions of the people who have testified and make arguments to the board.
Sure. Yeah, I'd like to be a
Okay.
party then.
Then if the board has additional questions about the elements that give rise to special damages, which include how close in proximity someone owns property to a subject, the property that's the subject of the variance request, and what harm this individual thinks they will suffer as a result of the granting of the variance request, that's the type of information that the board should hear in deciding whether you agree that he will suffer special damages or may suffer special damages such that he should be allowed to participate as a party.
Okay, so I don't have a map in front of me to really know exactly where Tremont is in relation to Waynesville Avenue. So if somebody can pull up Google Maps, or let me pull it up. Does anybody have it pulled up?
53. Yeah, you got it.
So I don't see it anywhere.
All right. Let me see your map.
Let's see your map. Here's the one.
So that's like a That's about
Right here,
5 blocks away.
Tremont, and then we're down here in this undeveloped spot.
Other than riding your bike or driving by it, what's your connection to the house?
Just a neighborhood resident, generally. Yeah, there's not an immediate connection. I understand that's the question of proximity. But yeah, I'm 1 block away from it.
I just think you're too far away to have a direct impact to the house.
Can I see that closer?
He's at least 5 blocks
It's a
away.
question.
Well, you may want to ask it as a question to say, what is your version of why you think your property would be negatively impacted by the granting of this variance?
I think access would be the big thing. I'm concerned about stormwater on Waynesville Avenue already being an issue when we have a large rain event due to the lack of infrastructure on Waynesville. The street regularly has a large amount of standing water on it during a large rain event that's hard to, navigate via bike, foot, or car. And I'm concerned as a part of the variance that we're impacting runoff and stormwater even more into the street by constructing impervious surfaces that are now pushing water more into the street rather than even less into the stream as it is right now.
Do you have any other direct impact concerns that relate to your property?
No, really, and coming from the landscape architecture standpoint, I really came not to directly oppose the variance, but to ask for conditions and to ask for a little bit more consideration with aquatic buffers, with stormwater mitigation, things like that. I'm not opposed to building on the lot, but I was hoping to voice some clarification from the neighborhood.
Has there been any impact in the past with your property that would be concerned with the five?
Just access to my property. This is the main way that we go to work. My wife works at Mission Hospital. I take my kid to daycare. We use Waynesville every day for commuting for childcare.
And so the board does not have to just either decide that you don't have standing and then prohibit him from speaking. You can allow someone to give evidence and not participate as a party. So if he's indicating to you, which I've just heard, that he doesn't want to argue his case for why this should be denied, it may still be reasonable and acceptable for you to hear whatever testimony he wants to give. And just acknowledge that he's not a party withstanding.
I think we're comfortable doing that. Tina? Yes.
Okay. All right, so again, my name is Micah Rogers. I'm a registered landscape architect, long-term Asheville resident, long-term. I'm from Brevard originally, been here 20 years. I live in this neighborhood, walk it, bike it, everything like that, like we've already talked about. And as a landscape architect that works with single-family residences primarily, I'm very, very familiar with the planning and zoning process. I've been to several of these meetings listening. This is my first time speaking with you guys. I've actually applied to be on the planning and zoning committee before, things of that nature. And my concern is, as we come into these substandard lots that are non-buildable, I am absolutely for building single-family residences. I think that we should maximize these lots because right now it's just a sea of kudzu and invasive species. But I'm concerned that we seem to be moving more and more, setting a precedent to just ignore aquatic buffers completely in the city. And I'm really concerned with if we keep on doing this on lots that get smaller. I was here for the neighboring properties meeting a couple months ago. These lots are getting smaller and smaller, and if we just start rubber stamping things and just completely ignoring the aquatic buffer and not asking for conditions up front, I'm really worried about long-term that, yes, it's a great idea to have a rain garden and a great idea to have rain barrels, but those require a lot of maintenance and a lot of care. And if we don't maintain those and if we don't do anything down the road, this creek that feeds directly into the French Broad a couple hundred yards downstream, I mean, literally you could almost throw a football to the French Broad from this lot. If we don't maintain the aquatic buffer, if we don't protect canopy trees, if we don't protect any kind of infrastructure and systems, we're just going to keep on decimating our wildlife, our streams, our water quality, things that people use for recreation, for water, for anything else. And I'm concerned in this particular instance that since it's a development and not a single family build, the people applying for this aren't on the hook to maintain it for years down the road. And to your point about the remediation versus stormwater mitigation and actually doing the stormwater calculations, I would really argue in this case, this is a site that really requires maintenance schedules and maintenance inspections and things of that down the road, so that it can't just be built and handed off to somebody and say you're clear, and they don't maintain what is effectively living completely inside an aquatic buffer and never having to maintain it at all. So I don't know the legalese and how to frame that within the framework of a variance, because again, I don't mind seeing it built. I think that this should be built on. If it shouldn't be built on, I think the city should purchase this property from the applicants and turn it into a park or a natural area. And that would be my personal preference, is that we see, again, walking down here, I see wildlife in here every day. I've seen everything from bears, foxes, deer, birds of prey, all kinds of things in this little wedge of undeveloped area right above Waynesville, and I would really love to see it maintain its quality as that. And really, the only way to do that would be for the city to purchase it and clean it up, put some native plants in, and let it actually benefit our streams. And again, I know that's not your purview. I realize that that's not on the table today, but just as a resident of the neighborhood, that's where I'm coming from. If it can't be that, let's build on it, but let's build on it more sustainably and in some manner, and not just simply rubber stamp it, say, yes, you can build in 100% of an aquatic buffer, and then they kind of have carte blanche at that point to go forward and kind of build whatever they want to, knowing that the buffer doesn't exist any longer. And if that's the point, then why do we have buffers? I think that's it.
Yeah, I mean, I hear your concerns and agree with some of them. The issue here is not necessarily, I think some of your concerns may be premature to what we're deciding here.
Yeah.
When they get into the other stuff, all we're deciding here is, can they actually build on it or not? And we have to decide from a hardship, and they have a hardship. We can't consider the pre-existing. So it's just, can they build on it or not? The concerns you have are to come, not from this decision today.
And you all do have the ability to attach conditions to the variance, though. So if you think that there's a way, even though the plans that you have right now are very conceptual, high level in nature, if you think there's a way to phrase conditions that would be advisable, you do have that authority to attach conditions to a variance. I just don't know if you have the information needed to be able to formulate those.
So we can attach to the variance, like a maintenance schedule.
So there's going to be there's a practical concern of enforceability. I mean, that's,
So, yeah. So
but if it sounds like you've got multiple people who really care about the same sort of subject matter, conditions on the ground and what it should look like. And so if there's a way to, not put all of your chair, but to craft the language to capture the types of green infrastructure that might be most helpful, it's within your power to do that.
And I think if I can just add one more thing, I think probably my biggest concern is canopy trees from a soil stabilization standpoint, and from the fact that you can't recreate canopy trees immediately, and we will be losing a lot of canopy trees off of this project, and that's something that, again, that's decades of growth, and they're so critical for stream stabilization. Again, I can say that professionally. I'm not saying that as a layman.
Any other comments?
I don't have any right this time, no.
Okay. Thank you very much.
Thank you, guys.
Yes, you may come back up.
As far as the trees go, I don't think we have any trees, maybe one.
There's 3 trees that will be cut, that need to be cut for the construction of the homes.
Yeah, we've argued about that. So we're trying to minimize that. We don't want the trees removed. Those trees are important to us, so just say.
Thank you very much. Okay, board. Is there anyone else here that wishes to speak? Doesn't look like it. Great. Board discussion?
We're just stuck in this loop of these lots that are unbuildable, but then they get sold and the hardship exists, and we're stuck on, do we agree there's an actual hardship that you can't build on a lot? And I have been being stuck in that loop. I hate being put in that position, because if it's an unbuildable lot, you shouldn't be building on it, but you can't punish them for buying a lot and then having that hardship. And if we're just purely deciding on a hardship alone, they have a hardship.
Well, I had a question as to why they're asking for variance for the aquatic buffer and not just doing the remediation itself.
That's a question for the applicant. I will say this, in my experience as a planner for these lots, let us start with the acknowledgement that all the good flat lots are taken. We will be seeing more of this. We will be seeing stricter ones. We will be seeing steeper slopes. We will be seeing greater challenges. That is the reality of development in Asheville in 2024. So when you have one that does have a federally recognized stream, or one where a determination has been made that there is a stream, it is not just the presence of water, there's invertebrates. That's why a stream bank isn't usually just where the water stops. It can extend much further because of soils and soil types. You have two options. You can either apply for a variance to go within the 30-foot no-build buffer as outlined in UDO section 712, or you can work with the Army Corps of Engineers to pipe this. Those are the two options presented to the applicant today. When you say remediation, there are several things that they can do within that, but it would not change the fact that the buffer exists. So they would have to do one of two things. They would either have to pipe it, or they would have to encroach in the aquatic buffer. So their method does not discount or is not mutually exclusive to buffer and stream remediation as well. However, if you do pipe this, if you go the route of getting an Army Corps of Engineer permit, obviously remediation is kind of off the table. So this is the most environmentally sensitive path, is what the applicant has expressed to us, and staff would tend to agree with that position, because this is one of those where there is an abundance of micro and macro invertebrates and animals and riparian environment that is valuable to the French Broad, which dearly needs it. Keeping the stream out of a pipe is the best way to keep all of this.
And I don't think piping it would get them out of trouble, because, and I wish we had somebody from Stormwater here to explain this, but where the pipe starts and where the pipe ends, you extend your buffer up or down the pipe another 30 feet. Their lot looks to be about where the stream is, let's just say it's 75 feet.
Yeah.
So 30, 30, 60, you've got 15 feet of area that they're eliminating from their aquatic buffer, but not the rest of it.
Yeah.
So does everybody understand that? The way that the 30-foot stream buffer is drawn, it's from top of bank up 30 feet. When you pipe it, at where the pipe starts and where the pipe ends, you go in 30 feet each direction, and that is also a stream buffer. So all of that area is still stream buffer. So for these people to pipe 75 feet of stream, they're still gonna have to contend with 60 feet of aquatic buffer that would need to be remediated, sought a variance for, or whatever. It's only when you have really, really long links for larger developments that it really makes a lot of sense. It doesn't really happen much with single-family residential, in my personal experience. So, so it's a little bit tricky. Piping it's not gonna get these people out of going somewhere, having to do some type of additional getting a variance or doing the remediation that's found in 10-141, which is a resolution that was set by City Council that allows you to permanently and temporarily impact an aquatic buffer. So, say anything wrong?
And yeah, the resolution 1041 applies to post-construction only, so the requirement for the variance is still there, even with mitigation, remediation.
Say that again.
So if you refer to the resolution 10141, table of uses for post-construction aquatic buffers, so they still need the variance to get the construction permits, the building permits in the first place.
prior.
Oh, because they have the chart
Yeah.
of what's allowed
Yeah.
and what's not allowed.
Mhm.
Correct.
Okay, thank you.
Mhm.
That was the question that I wanted.
Okay, yeah.
So this is
I know it's an answer.
Right.
Yeah, so they would need,
Pre, they wouldn't need it.
Mhm.
yeah, within that, there's different uses that are allowed as temporary impacts and permanent impacts, and a lot of them are like grading or
Okay,
doing a greenway or.
Deck,
things like
yeah.
that. So,
okay.
okay.
I would
Any-
love to find a way to attach some kind of provision or whatever that they're recommending, but I don't think any of us are capable of able to do that. And, I mean, just to be frank, I wouldn't even know how to start on that. And, I mean, we gotta set some kind of precedent on this stuff, because it's a yes on the hardship, but if we keep saying yes, and the loophole is all they gotta do is buy a lot that's unbuildable, and they suddenly have a hardship, I'm not happy with that. And I'm not happy with that, that's just the way it goes.
There's a finite number of how many of these lots exist because we now have lot size standards. So it's not like somebody could take a appropriately sized lot, subdivide it down to a ridiculous size, and then sell them, and everybody that buys would be able to obtain a variance. You just can't subdivide below a certain standard now, but for lots that were created before the existence of the City of Asheville zoning code, that they're just in existence already.
Yeah.
We're just not getting any new ones because of those lot size standards.
That's right. So in terms of the unique circumstances related to these two parcels, having these substandard lot sizes, predated the ordinance, and it sounds like what the situation was. And to that point, predated having a stream buffer applied to it as well. So if those homes, if there were homes there, they would just be pre-existing non-conforming homes because they're already there. So I think that because of the unique circumstances of them being substandard, they are seeking to move the homes closer to the street, further away from the stream bed and out from the top of bank. I think that is a positive. Their building plans look like they're making the recognition that they need to do slightly different building type because of the stream buffer. So I think they're trying to make inroads in addressing this aquatic buffer. And obviously with the applicant stating that she really wants to have a robust landscape, and although I would caution us tying any condition using language that would require them to hire a civil engineer or landscape architect to do stormwater calculations and create an operations maintenance manual, in my mind goes a little bit above what
I have to agree.
what
with you.
seems reasonable.
Yeah, so-
But I would entertain somebody coming up with some other language if they can think of it.
Madam Chair, so just the easy one might be, I heard appreciation of was it cantilevered or piered construction? I don't know what the correct term is.
It's cantilevered construction.
That could certainly be a condition, is that the building type has to be the cantilevered construction type identified by the applicant. The other thing that you could do is if you're comfortable with attaching your own language or describing it in your own language, you could have the applicant describe to you what they were planning to do in terms of the green plantings and whatever that they were intending to put in to help remediate the condition on the site, and then incorporate those as conditions for the variance.
So their intentions.
Yeah, Sam?
Yeah, there may be some stormwater issues with those, because once you identify a rain garden or a French drain, suddenly there's outfall calculations, then there's a stormwater, it becomes a much larger stormwater thing that is evaluated at the same level a level 1 or a level 2 residential development would require, rather than a single-family home permit.
Plantings, no concern with that.
Plantings are not a concern, but it's
Plantings
once
obviously
rain
would be
gardenments,
controlled.
catchments,
So
outfalls,
maybe avoiding
drains,
any
yeah.
terms of art that relate to stormwater conditions and describing.
Right, once you start creating a depression for water to collect, they want to know
Yeah.
how much water and what is it lined with and where is it outfalling and
Right.
all of that. So,
And
Tyler.
the remediation plan will be reviewed by myself as well as the stormwater team, you know, as far as the plant list, the location, any trees that they remove will most likely have to be replaced with a similar species. So as far as to the tree canopy, you know, that's kind of addressing those types of concerns. So that would definitely be a part of the administrative level review for these two subject parcels, as well as any of these Waynesville Avenue properties in the future. So you don't have to necessarily condition those types of things because those are already a part of the review process.
So the intention is part of the variance, is my understanding, am I correct?
The mediation, remediation, and stormwater grading and erosion plans are all part of a typical review for any properties within the aquatic buffer or tree canopy area, tree canopy protection area, floodplain, you know, list goes on. But to clarify, I'm just saying that you don't have to necessarily condition specific things because there's already built-in coverage within the city's ordinance.
So intent could cover that, am I correct? Or no?
He's saying we don't need the condition.
We don't need the
Because
condition.
they're already there.
Not like specifically to plant list or,
You'd
yeah.
only need to attach a condition if they're proposing to exceed whatever is in our code. And if they are voluntarily proposing to exceed whatever is in our code, then you could, but I have no idea what's envisioned, because I don't know if this even exceeds.
This is a very, very comprehensive landscape plan, or at least the plants that are listed and mentioned, which I think is fantastic. I think that the applicant also needs to be aware that whoever ends up with these parcels is going to be fighting most likely a losing battle with the invasive species that are in the area. So I love people that want to try. It's very costly to battle invasives unless like an entire neighborhood block gets together and tries to get it from asphalt to asphalt. So
That seems terrible in there.
it is terrible in that area, and there were quite a few others that showed up in some of the photos. So I would say if we wanted to craft some type of language that talks about plant material, we could talk about utilizing the city of Asheville's plant list that talks about riparian plant material, and just leave it at that, because stormwater is going to be working with you pretty extensively. They're going to probably ask for you to do some live staking just to secure the bank as quickly as possible. So I think we should leave it up to the department that really has the expertise in that and just refer to the recommended species list for stream buffers.
Certainly.
Unless somebody else is. Does that make sense?
Yeah, that makes sense
That
to
makes
me.
sense.
Yeah,
It's pretty comprehensive, and it is broken out into stream areas and
Well,
things
we're not
like
doing
that.
it, so they might as
I feel
well.
like I'm deceived. You know,
We're not coming up with it right now,
I don't
guarantee
think
you that.
we want to come up with a plant list for
No.
a variance, frankly, but.
And there is a company that's out of Burnsville that is actually recommended through RiverLink, but I had actually checked them out before, and they do work with a lot of the local landscapers just in indigenous and local plants. So they can put us in touch with the people that would be best for this.
You can hire a stream bank restoration company just to do the landscaping, and not that you're really doing a restoration, but just for your disturbed area.
I'm personally still stuck on the hardship, and I think this hardship's carried with the property, and now we're just facing it. I don't think that's going anywhere, but I don't think it's right to treat this property like there's already, if there was a house there, we've said that we would treat this differently. I don't think we should treat it that way. There's not a house there. We have a certain number of streams and clean water available left in this county. And trust me, look, if this lot came available, I have investors, a realtor, we would have bought it faster if we could build on it. And I don't think that that's something that we need to look at personally. And there are even ways, if the person you bought it from is a realtor, potentially that you can go back through the legal process to do that. I don't know your situation. I'm very, person to person, I can imagine I'm building a house right now, and I can imagine like that situation. Also, a consideration is this is not the end user, so if they decide, the next person decides to change that property down the line, put all grass, do whatever they want to put a concrete backyard, who's gonna stop them? I mean, they're not gonna concrete, but
Yeah.
I'm being a little bit of hyperbole, but
Yeah.
this is a one-time, they're gonna build it, probably sell it, and, what does that do to stormwater and other effects? That's my main concern.
No, it's a concurred concern, but the hardship is very black and white on this one. That they have a lot to build a house, they can't build a house, done. That's the hardship. I agree with this sentiment, 100%, but that's not the decision here. The decision is, do they have a hardship? Yes.
So with that being said, is there any other discussion? And before anyone does make a motion, do we want to clarify whether they want to address that potential side setback encroachment?
I did include it in my application, and it was scaled off of the survey, but also agree with Sam. We were in somewhat of a time crunch to get all this together for the meeting today, so I asked the surveyor, can you overlay this 24 by 24 on the survey showing a proposed 10-foot setback? So I don't know, they did not pin that, so to speak, in the field specifically.
So what I'm seeing is that it's not a perfect rectangle. Those lines, your side setback, your side property lines are not equidistant to one another.
It's possible that the overlay they have on there, the 24 by 24, isn't accurate.
What I think we're attempting to do is to add that to your variance request so that you do not have to come back here in case there is an encroachment when you get out into the field. So erring on the side of caution.
It was on my application.
Okay. So let's add that to our variance
So that would be,
request for setbacks. So it would be what's the,
That is 1.2 feet
Thank
in the encroachment. That would be for the side setbacks.
1.2 feet?
Mhm.
20%, yes. And just to, address one of the other points brought up, that, if someone were to, hyperbole mention, pave the aquatic buffer, they certainly would receive a notice of violation. I think the neighborhood has a lot of attention on this creek, so not saying that that's full future-proofed, but, we saw at the last meeting, obviously there's members of Riverlink and other organizations that are also in the area watching the development around Waynesville Avenue, so.
I understand. And just to be clear, we're talking about including the driveways, probably 1,400 square feet of impervious surface, adding to a large watershed that dumps down into an industrial site that creates beer
Yes.
in the floodplain.
Yeah, you didn't mention that.
City-sponsored project.
I understand. And I understand the stormwater management that was involved, but just perspective of size, I think is important. Okay. Any further discussion? Does someone have a motion?
Yeah, I just think we're under I think the board has approved all variances like this when you have these old lots. that unfortunately are just grandfathered into these new things, and it's just, I agree with your sentiments, Chris, but that's unfortunately not the decision we're making, I think. So I'll motion to approve the
And then you need to list any conditions that you're attaching, so I would say, subject to the condition that, and if it is just, and I don't know if we're gonna take a stab at more than one, but if it's just that the construction methods will utilize cantilevered piers, or however is more appropriate to say that.
I'm gonna see.
That cantilevered piers is how I would word that. I did have a question. Are we doing all of the variances at one time? Are we doing setback variances?
I would recommend doing this, and then Eric can clean up after me. So there are two properties here. There's parcel 1 and parcel 2. It is only parcel 1 that is looking at that 20% side setback encroachment. I would do this. I would do a motion for parcel 1, the appropriate address on that one, and say that this is for the front, the pre and post construction aquatic buffer disturbance, and the side setback, and then do one without the side setback for parcel 2. So there are actually going to be 2 votes, 2 motions, because they are sufficiently distinct enough with the introduction of this new side setback matter.
Am I doing it?
Somewhat, I say.
I motion for 1 for the 20%, and the second to, as is.
So I think what he was saying is that I make a motion to approve the variance for parcel 1,
Correct.
reducing the 15-foot setback to 10 feet and reducing the 10-foot side setback to 4.8, which is a 20% reduction.
6-foot side, you said 10-foot side.
Oh, I'm
Yep.
sorry, 6 foot, yes, yes, 4.8. And then if do you want to say the aquatic buffer stuff?
Oh, yeah.
I'm like, what does the application say? Yes, let's see. As well as to approve the reduction in the 30-foot aquatic buffer to near zero for construction of a single-family dwelling on the subject parcel. Each, or the home to utilize cantilevered construction methodology in the rear, and to work with the stormwater management department on remediation utilizing the City of Asheville's recommended species list.
Is there any distinction between piered cantilevering and just cantilevering generally? Do we need to, okay, all right.
Great.
I'll second that.
Okay. Great. All right. Board members, when I say your name, please say aye or nay. Elliott Smith?
Aye.
Tina White?
Aye.
John Michael Cletus?
Aye.
Chris Van Danish?
Nay.
Suzanne Godsey is an aye. Variance is approved. All right. The second one. We're not done yet. So for parcel number 2, we are, I will make the motion again to approve the variance requested for a 10-foot front setback, which is a 33% reduction from the 15-foot setback, a reduction in the 30-foot aquatic buffer to near zero for construction of a single-family dwelling on the subject parcel, and to include, may I please say, all the language in the previous variance? Minus the side setback reduction. Can I get a second?
Second.
Great. All right, when I call your name, please say aye or nay. Elliott Smith?
Aye.
Tina White?
Aye.
John Michael Cletus?
Aye.
Chris Van Danish?
Nay.
Suzanne Godsey is an aye. Variance is passed. Okay.
Okay.
Let's see. Is there any other comments? Anything else? So next month we'll do the appeals? Okay. If there are no other objections, we will adjourn the meeting. Are there any objections?